Mr. Scott?
Yes.
You can come on here, please, and have a seat. We will go on the record in the matters 25 TR 514, Tony of Burnett versus David Scott. The state appears through District Attorney Kevin Schmidt in person. Mr. Scott appears in person without counsel. We were set here today for a court trial in this case. The matter has been set for a significant amount of time. It was set on July 8th, 2025. On July 8th, 2025 was when Mr. Scott entered a not guilty plea to this matter, and the court has set the matter and waited for today.
Your Honor, could you repeat that, please? When was the not guilty?
July 8th, 2025, a not guilty plea was entered into the system.
What form?
I don't know.
Okay.
It wasn't in front of me. You didn't come in front of me. All I know is that if you did not enter a not guilty plea on July 8th, 2025, it would have been a default. You would have been found guilty automatically. So you did something to say not guilty, because I'm going to tell you, my clerks are directed that, and because it's the law, if you do not enter a not guilty plea as of the date you're told that that is the date, it is a default and you are found guilty of that offense. So as of July 8th, 2025, you entered a not guilty plea as to this ticket matter. However, the matter was set for today's date and time way back on July 8th, 2025. However, on November 14th, but maybe there was something, on November 4th, 2025, you filed a motion to dismiss this matter, which the court has read thoroughly. And then on November 14, 2025, I believe you filed 6 or 7, I don't have the exact count, but I have reviewed every single one, 6 or 7 motions for the court to hear. The court did enter orders as it relates to 4 of them, I believe, or 5. 1, 2, 3, 4. 4 entered denials as it relates to 4 of the motions that you have filed. One of the motions, I believe, was directed to...
Now the action heats up. Mr. Scott demands full discovery, body cam footage, radar records, dispatch logs, technical data, and more. The judge walks him through the rules and the fees, reminding everyone that this isn't simple paperwork. This is the battlefield where evidence can make or break the case. Viewers get a front row seat to a fight for transparency and truth, and the suspense is sharp because every document matters.
The Sheriff's Department and the District Attorney, as it relates to preserving evidence. One relates to, I think, the FOIA request, Freedom of Information Act request. And so the court does not need to rule on those matters. So I believe outstanding matters that we have here today would be a motion to dismiss and a motion to compel discovery. I believe that is all that is open and outstanding. Therefore, the court is allowing you to argue those in front of the courts before we proceed and have a court trial, because quite honestly, if you want discovery, you're entitled to discovery.
I would like discovery, please.
All right. So,
and also, I put a motion in. Is that too loud?
It is kind of loud.
Okay.
So you can talk from a back, and so you know,
Okay.
and this is my court reporter right over here. She has very good ears, but she needs you to speak. You don't speak into the microphone.
Yep.
And that should be enough. Enunciate your words and don't speak too fast, because she literally types down everything that is said. Which is amazing, and stenographers are amazing and wonderful. We need more of them.
So let me start off by saying, basically, the way I view this is as a discovery hearing. I'm asking for practical, low-cost access to core materials so I can prepare my defense. I've been incredibly transparent as far as what documentation and the timelines in which the case pretty much evolved. Not the case, but just the citation. And there's a lot of things that just, you've read it, a lot of things that just don't line up correctly.
And so, you know,
And-
I want to say, sometimes it's nice to get motions in tickets like this, because otherwise all I have to go on is the simple ticket that says
Right.
speeding ticket, et cetera. So with your motion to dismiss, I got some background.
Okay. I appreciate you looking at that, Your Honor. I mean, so basically when it comes to the motion for discovery, I'm looking for reports, body,
Body cam.
dash cam, dispatch, CAD, ALPR, flock logs, and radar device records, make, model, serial, operator training, calibration, maintenance, pre-post shift checks. I'm requesting under the order of Wisconsin statute 345.421 with the production under statute 804.09 on reasonable terms, meaning length, email, or on-site inspection, and if needed, a short continuance so I can review.
Okay, all right. Mr. Schmidt.
I can maybe shortcut this. I think this issue is moot now because I talked with the defendant yesterday. The main issue is he just didn't want to pay any money for the discovery. Yesterday, he indicated to me he'd be coming to court today and pay for it and pick it up. It's ready for him in our office.
All right.
Yeah, that's fine. I mean, I'm
I think
fine with it.
I'm going to tell you, I don't know. I've been on the bench for 8.5 years now. So I've not been in the shoes of an attorney for a long time. I think, isn't discovery like $20?
It's less than that.
Okay, so it's a nominal fee.
Mhm.
Okay, I'm going to tell you, it takes a whole lot more than $20 for the officers and everybody to gather this information, because
Mhm.
it's a lot.
The courtroom then takes a personal turn. Mr. Scott shares his life, education, and family ties, transforming this from a routine citation into something deeper. We feel the weight of the moment as the judge listens. This is now a question of identity, fairness, and justice, not just a speeding ticket. Every detail could influence what happens next, and the tension continues to rise. Clapperboard clip
Goes into compiling the evidence
Right.
and the discovery, and to be shot over to the district attorney's office for a case, but they only charge that nominal $20 fee.
So there was an email chain that was going forward, and I mean, I'm not gonna lie, I was a little bit bitter about the situation at one point. At this point, I understand, you know, everybody's time is valuable, including yours and Kevin Schmidt, the
I
district
respect that.
attorney.
Thank you.
And it's, I mean, I just want to resolve the issue for the most part. That being said, like, this is a case of mistaken identity. But that being said, I mean, coming here today and being here and having to come back and whatnot is an inconvenience. So for me, I mean, I would like to work with the district attorney to try and come up with a solution, whether that be, you know, I mean, I feel confident that this is, you know, like pretty much a scenario like this is never going to happen again because it's just a fluky situation from my perspective. That being said, I feel like a fair plea would be something along the lines of entering a not guilty, but at the same time, maybe going through something similar to a diversion type program. So that way the charges are not on the record, but diverted to a future date.
Mr. Scott, I'm hearing you and I understand.
Mhm.
In my position in this chair, I can hear what offers are.
The judge ends the hearing with clear instructions on discovery objections, and the upcoming trial. The session closes, but the conflict remains unresolved. Now, Mr. Scott must prepare strategically for the next encounter. This has become a masterclass in courtroom procedure, showing the stakes, the rules, and the human story behind the law. Don't forget to like the video, subscribe to the channel, and stay tuned for the next chapter.